What's going on? YouTube, listen up, young elder gang. This is Shalonda Lewis at you with another banger. Please make sure you like, subscribe, and share this video, fam. I hope this video get at least 100,000 likes in this video. You will find history definitions, scripture information, and best of all, what we Americans have been deprived of from the beginning. The truth, keep in mind, this content used in this video is intended for entertainment, educational and informational purposes only. We will give you the total truth as we best understand it today. Be sure to hit that like button, young elder gang, hit that subscribe button if you're new to the channel, hit that bell, and don't forget to check back with us every day for new content. Power in America doesn't always wear a suit and tie or give speeches on TV. Sometimes it whispers in the halls of obscure agencies, hidden in the footnotes of thousand-page regulations. For 40 years, a legal ghost named Chevron haunted the system, telling judges to defer to agency experts. It became a playground for the powerful, especially in banking, letting them build a fortress of complex rules. Now, with Chevron gone, we're left to sift through the wreckage and ask, what comes next? So, what was Chevron? Not a gas station, but a legal doctrine born from a 1984 Supreme Court case. It was a two-step test for judges reviewing a federal agency's interpretation of a law. Step 1. Did Congress speak clearly? If yes, follow the law's plain meaning. But Congress is rarely clear. Laws are full of vague phrases and ambiguity. Step 2. If the law is ambiguous, is the agency's interpretation reasonable? Not the best, just reasonable. That's a low bar. As long as the agency's rule wasn't absurd, the court had to uphold it. Judges became rubber stamps, and lawmaking was effectively outsourced to the executive branch. Agencies were told, "See that vague law? Go nuts." It was sold as respecting expertise, but in practice, it created a power vacuum. And who filled that vacuum? The bankers, lobbyists, and financial elite. They guided agencies toward reasonable interpretations that served their interests. Chevron was the silent engine behind the rise of financial power. How did Chevron become the bedrock of a banking empire? Simple banking laws are ancient, complex, and vague. Statutes like the Glass-Steagall Act never imagined modern financial products. This ambiguity was a feature, not a bug. Bankers could approach regulators and say, "The law is silent on this risky thing. Let's call it reasonable." The infamous revolving door made things worse. Regulators crafted rules favoring banks, knowing lucrative jobs awaited them. Chevron protected these pro-bank interpretations from judicial review. Consider the explosion of derivatives before 2008. Were they insurance? Securities? The law was unclear. The Commodity Futures Trading Commission, under pressure, decided these didn't need strict regulation. Courts, citing Chevron, agreed. A multi-trillion-dollar shadow banking system flourished, unregulated. The result, a banking sector with near-total impunity. Courts would ask, is the agency's interpretation reasonable? The answer was always yes. Chevron became a judicial shield, letting the financial elite write the rules. They weren't just above the law, they were making it. The 2008 financial crisis wasn't an accident. It was the result of thousands of choices made in regulatory offices, with Chevron deference hovering over them all. The crisis was fueled by bad mortgages bundled as safe investments, but the real poison was unregulated credit default swaps. This shadow market, enabled by Chevron, let risk multiply and spread globally. Warnings were ignored. Regulators, protected by Chevron, decided oversight wasn't needed. Their reasonable interpretation was that the market would regulate itself, a catastrophic mistake. Banks took on insane risk, using leverage and complex instruments, because regulators, shielded by Chevron, blessed their existence. When the housing market collapsed, the system crashed. AIG, overloaded with swaps, needed a massive bailout, all by design of world banker elites. The 2008 meltdown was the price of unchecked agency power and decades of letting bankers write their own rules. Chevron's system prioritized expert interpretation over accountability and failed spectacularly. The watchdogs were told to heel, and the courts were required to look away. The U.S. Supreme Court ended Chevron deference in the case of Loper Bright Enterprises versus Raimondo, 2024, holding that courts must interpret ambiguous statutes independently and are no longer required to defer to a federal agency's reasonable interpretation. The court reasoned that this new framework is more consistent with the Administrative Procedure Act, APA, which it found Chevron deference to violate, and that agencies do not have greater expertise than the judiciary in statutory interpretation. While existing regulations remain, the ruling makes it easier to challenge agency rules and may slow future regulatory expansion. 2024 decision: the Supreme Court overturned the Chevron doctrine that had been in place since 1984. The court determined that the Chevron principle was fundamentally misguided because it wrongly assumed that statutory ambiguity constituted a delegation of authority to agencies. The majority opinion, authored by Chief Justice Roberts, held that courts have the fundamental duty to interpret the law themselves, not to defer to an agency's interpretation. The court found that Chevron deference was incompatible with the APA, which requires courts to interpret statutes independently. The court also rejected the idea that agency expertise makes them more qualified than federal judges to interpret a statute. The responsibility for interpreting ambiguous statutes has shifted from federal agencies to the judiciary. Regulations that were previously upheld under Chevron are not automatically overturned. They will still be subject to stare decisis, the principle of following precedent. Courts will now apply their independent judgment to determine if an agency's actions align with its statutory authority. They will still consider the agency's interpretation as potentially persuasive, but only if it is well-reasoned. The ruling is expected to lead to more litigation, as it will be easier to challenge regulations that lack clear congressional authorization. The decision may lead Congress to write more detailed statutes in the future, rather than leaving broad policy choices open for agency interpretation. Like any monster, Chevron eventually had to be confronted. Backlash built for years. Conservatives saw it as empowering unelected bureaucrats. Progressives saw it as corporate capture. The stage was set for a Supreme Court showdown. The final act began with a case about herring fishermen, Loper Bright Enterprises versus Raimondo. The National Marine Fisheries Service interpreted a vague statute to make fishermen pay for government observers. The agency pointed to Chevron. The fishermen said it was overreach. In 2024, the Supreme Court openly questioned Chevron's legitimacy. The majority declared the doctrine inconsistent with the Administrative Procedure Act. The era of judicial deference was over. Judges would now exercise independent judgment. The ghost was exorcised. Chevron's 40-year reign was dead. The fortress of paper had been breached. But no one was sure what would happen next. The rules of the game had changed overnight. The future of financial regulation was suddenly up for grabs. So, the beast is slain. Hooray? Maybe. Critics hail Chevron's end as a return to the rule of law. Courts now check agency power. Regulators must defend their rules before skeptical judges. Congress is pressured to write clearer laws. Agencies must build stronger cases. But the balance of power shifts. Agency power shrinks, judicial power grows. For finance, every new rule is now an invitation to a lawsuit. Elite banks with armies of lawyers can challenge any rule, bogging down regulation in endless litigation. Without Chevron, courts could reach wildly different conclusions, creating a patchwork of laws. Regulatory paralysis looms. Agencies may stop issuing new rules, fearing court challenges. The the watchdogs might be muzzled by 1,000 lawsuits. The future of financial regulation is uncertain. We may have traded the tyranny of the expert for the chaos of the courtroom. Chevron deference benefited world elite bankers by allowing federal regulatory agencies, such as the Office of the Comptroller of the Currency, OCC, to issue interpretations of ambiguous banking statutes that expanded banks' powers with minimal judicial interference. Congress passes broad, complex financial legislation, leaving certain terms and the scope of new financial activities undefined. This ambiguity leaves regulatory gaps that agencies are tasked with filling. A federal agency, influenced by lobbying and the revolving door between the private and public sectors, interprets the ambiguous statute in a way that permits large, elite banks to engage in new, potentially high-risk activities, e.g., specific derivatives trading or new forms of lending. When consumer advocacy groups or smaller competitors challenge this interpretation in court, the courts apply Chevron deference. Under this doctrine, as long as the agency's interpretation is deemed reasonable or permissible, even if the court might have a different interpretation, the court must uphold the agency's decision. Expansion of power and profit. This judicial deference allows the elite bankers to proceed with their expanded activities, generating significant profits without the legislative process explicitly authorizing these actions. The deference shields the agency's interpretation from rigorous judicial scrutiny, making it difficult for opponents to challenge regulations on their merits. This provides regulatory certainty for the banks, knowing that their business models based on these interpretations are unlikely to be overturned by judges. Imagine Congress passes the Cryptocurrency Stability Act, CCSA, to manage the risks posed by volatile digital currencies. The statute includes ambiguous language, such as authorizing the Federal Reserve to implement necessary and appropriate measures to integrate digital assets into the existing financial framework. Chevron deference benefited federal banking control by strengthening the regulatory authority of agencies like the Federal Reserve, the FDIC, and the OCC. This allowed these expert bodies to issue robust rules to ensure the integrity of financial markets without facing frequent judicial second-guessing, thus promoting national consistency and stability in the banking system. Under the original Chevron doctrine, the Federal Reserve, leveraging its specialized expertise, issues a comprehensive set of regulations through the formal notice and comment process. These rules impose strict capital and liquidity requirements for banks dealing in crypto assets, a move that the banking industry considers overly burdensome and an expansion of the Fed's statutory authority. A group of financial institutions sues the Federal Reserve, arguing that the agency's interpretation of necessary and appropriate is too broad and that it should be a court's role to define this term. Applying Chevron deference, a reviewing court would engage in a two-step analysis. The court would determine that Congress did not directly address the precise issue of specific capital requirements for crypto assets, leaving an ambiguity in the statute. The court would then defer to the Federal Reserve's interpretation, provided it was reasonable given the agency's mandate to ensure financial stability, even if the judge might have preferred a different interpretation. Outcome and benefit. Where the court upholds the Federal Reserve's stringent rules, allowing the agency to move forward with nationwide consistent regulation. This benefits federal control by providing regulatory certainty and stability across the national banking system, as banks and markets must adhere to a single expert-driven standard. Without Chevron, courts across different jurisdictions might have issued conflicting opinions, leading to a fragmented and less stable regulatory environment. This is how Chevron empowered agencies to make policy choices and leverage their expertise to manage complex, evolving areas like financial markets, securing more effective and consistent federal control. The Chevron deference allowed agencies like the Office of the Comptroller of the Currency, OCC, to interpret laws broadly, effectively permitting banks to engage in expanded activities, such as certain investment banking functions alongside commercial banking, that might otherwise have been deemed too risky or outside their original congressional mandate. Regulatory loophole creation. This regulatory latitude meant that, in a hypothetical scenario, elite bankers could push the envelope with complex financial products and strategies, like certain mortgage-backed securities, that were technically compliant with the agency's reasonable interpretation of the law at the time, even if those interpretations enabled systemic risk. Insulation from legal challenge. Chevron deference meant that legal challenges to these agency-approved activities were less likely to succeed. Banks operating under these broad interpretations were somewhat insulated, as the courts were predisposed to side with the regulator's expertise. If a risky practice led to a crisis, the bankers might point to the legal regulatory framework, backed by Chevron deference, as their legal justification. Lack of accountability. In a crisis, the deference meant that the agencies, and by extension, the bankers operating under their rules, had less judicial oversight. This could lead to a situation where, despite massive global financial fallout affecting the broader economy, the elite bankers themselves could avoid direct legal culpability because they were technically operating within the accepted, albeit expansive, regulatory interpretations of the time. In this view, the harm to the bankers might not be immediate financial loss, but rather a long-term exposure to systemic risk that eventually led to a crisis and subsequent intense public and political scrutiny, which in turn could lead to new, stricter regulations or reputational damage. The death of Chevron doesn't stop at America's borders. For decades, it was an unspoken pillar of global financial governance. International bodies like the IMF and BIS set standards, which U.S. regulators translated into domestic rules. Chevron let agencies align U.S. rules with global standards, creating stability. Now, that mechanism is broken. Without Chevron, U.S. agencies' attempts to implement international standards are vulnerable to legal challenge. Banks can argue that new rules aren't the best reading of U.S. law, and judges might agree. This could decouple the U.S. from global financial consensus, triggering a regulatory race to the bottom. The post-2008 consensus on stronger coordinated regulation is at risk. The end of Chevron could isolate the U.S., turning it into a regulatory rogue state. Instability could spread from the U.S. to global markets. The dominoes, once neatly arranged, are now wobbling. A legal doctrine's quiet death in Washington could shake London, Tokyo, and beyond. The world is watching and worrying. Here we are, standing in the ruins of the old order. Will killing Chevron restore public oversight and democratic control? The optimistic answer: yes. Courts, not bureaucrats, now decide what the law means. Congress must write clearer laws, and shadowy deals are dragged into the light of the courtroom. But there's a darker possibility. We've traded one form of elite control for another. Power shifts from agency experts to federal judges, who have their own biases. Judges may substitute agency bias with their own, and those with resources, big banks, can wage endless legal battles. Community groups and consumers can't compete, risking even less regulation. The public may have less of a voice than before. The hidden power of the banking elite may now flow through the courts, not agencies. The fight for control of the financial system continues, now in the courtroom. Ending Chevron was seismic, but not the end of the story. We may have slain one ghost, only to find another waiting in its place.